Hello, welcome to the first weekly video for legal research for 2018. In this video I'm going to give you the introductory drill on the subject, what you can expect, how the process is going to work, and more importantly I'm going to focus a little on the law reform paper that will be the backbone of our work this term and which your research questions will be taken from. Alright, so first of all, briefly, how is this going to work each week? Well, my expectations are that each week you'll prepare, you'll read your study guides, you'll do your readings, and you'll have a look at the weekly task for the workshop for that week. And these videos will be uploaded the week beforehand to give you a bit of an introduction and a guide through that process. Now, the one thing I won't be doing is summarising any of the material that's in your readings or the study guide, because if it was something that I could summarise, there'd be no point in me giving it to you as a reading or putting it in the study guide. You know, that makes sense. If it was something that was so simple you could deal with it in a half an hour of a video, then we would do it as a video, because it would be inefficient and silly just to give you extra reading to do just for the sake of it. So everything that's in there is there for a particular reason. It's important that you read. There's a lot of reading in this subject, but what we also do is point you to some resources on active reading and help you improve your reading skills, because one of the things you really need to learn as a lawyer is your ability to read actively, to skim, go forward, go back, and not to read as you would read a novel or something like that. Okay, so my expectation is that there will be preparation beforehand, and that these videos will then be the staging point to say, well, what do we do with that? How do we use it? Just reminding you that there will be no summaries of that material here, and that's what you'll need to do for yourself. All right. So in this unit there are weekly workshops, and they're the ramp tasks each week are a particular challenge around your research topic. And the idea of this, as I think I've mentioned in other videos, is to model the research process, to give you a sort of a 12-week model of how the research process works. It's a sorry, I'm just recovering from a cold, if you couldn't have guessed that. But the idea of the ramp modules is to give you that scaffolding of how a research process works. Now, most research processes aren't going to be 12 weeks long. They're going to be longer or shorter, and you need to evolve your own approach at how you approach research. But at a first introduction to the subject, I think it's good for you to get an idea of a scaffolding, of a model of how research works, that you can then go and adapt yourself to your own processes. Now, each of the weeks in the workshop will generally focus on that task for the week, and I'll be working through a question each week to give you an example of how to work through it. There will be other time available to answer other questions or to discuss things that came out of the readings or general questions or whatever, so we're not going to fill up the whole sort of hour each week just with that task, and you'll have time to ask your questions there. But the primary purpose is for the workshops to be that practical activity where you can actually see and engage in research in a practical way. Now, this will also be supported by videos, and there are 3 types of videos in this course. There are weekly videos, there are key concept videos, and there are external videos. So the weekly videos are like this one, and I'll be producing them each the week beforehand and uploading them, and that'll be a general introduction to the workshop for that week. Now, there are previous year's videos on YouTube out there, and make sure you're looking at the current 2018 ones, not the ones from previous years when you view those. And I will try and figure out how I can set up my playlists to make that more apparent. But there's still going to be a situation where just through the YouTube recommendation system, you'll find that there will be old videos that will pop up in your list. So make sure you have a look at the dates on them. I'm now putting a 2018 date on the video card to try and make that a little bit more apparent. Okay, so the first type of these introductory videos I'll try not to be as very rambly in them, but sometimes they will get a bit rambly. The second type are the key concept videos. Now, they don't get updated every year, and they focus on specific concepts, and the idea is just to look at in depth in a particular topic, and I'll be producing more of those throughout the year and putting them into the playlist as well. But they, as I said, they'll only get replaced once the information becomes old and outdated, and they need to be replaced. The third type of video is the external video, which are where I point you to other resources on the net that are useful to you, and there's particularly a lot of good resources on study skills and well-being skills that I refer you to each week. Okay, any other general business before we start? Yes, there's I'm available for consult times each week. The times will vary from week to week depending on my appointments. I'm acting head of school, actually acting law dean for the next 6 months while Stephen is on study leave. So my time is going to be a little bit more chaotic than it used to be, and it's going to be a lot more difficult for me to find regular time for these, but I will put a link to my Google Calendar up there, and you can see what slots are available and book them in ahead of time. So apologies in advance that my schedule is going to be erratic. However, and I would much rather be doing this than doing most of the things you tend to do as a dean, which are, ticking lists and signing off documents and very not very exciting things. But that will mean that from week to week you'll be able to see what slots are upcoming for consultation times and book in the time as either a phone call or a Zoom session where you can have a chat about anything relating to the unit or your studies. So please feel free to take advantage of that. It's not an imposition, it's what we're here for, and it's something I think students get a lot of benefit from, but some students are also a little apprehensive about things, saying, although you're very, very busy and not booking the time. Please, it's a pleasure to have those student consults, and I make that time available for that reason. All right, so let's get into the actual task that we're focusing on in this particular unit. Now, this subject's a very practical subject based around the idea of legal research, and this is something that I think you can only learn by doing. It's not something you can study in the abstract or hypothetical. So what we do each term that this subject runs is select a law reform issue, a law reform inquiry, and extract the questions that you will be answering from that particular inquiry. And you'll be allocated a question, and you can see the details of that in Moodle from the particular inquiry, and you will work on that throughout the term. So we have the RAMP modules, which are the weekly modules, which you develop your topic and work on it stage by stage regularly throughout the term, and then submit each of those modules as a portfolio at the end. There is an early plan that you do so you can get some feedback on it, and there's the final assessment, the final assignment that you put in, which is 2,000 words. It's deliberately nice and short, so you can really focus on having that sort of laser focused precision in what you write, because there really isn't time just to preamble and waffle and talk around the issue, and that's one of the areas where students generally fall down in written work, is they spend way too much time waffling and not enough time actually digging into the issues. And we're going to talk about that more this term and develop those skills so that you're a much better researcher and a much better communicator. Alright, so the topic we are selected this term is the Royal Commission into Institutional Responses to Child Sexual Abuse, which is a pretty heavy topic. Ordinarily what I like to do is to pick an inquiry which is ongoing, where you'll actually have an opportunity to submit a public submission to the inquiry at the end of your studies, so that you can write your assignment and then submit it to the inquiry. Now, that hasn't been possible this year. There is nothing at all open at the moment, and I've held back on choosing something for as long as I can, hoping that something's going to be announced, but it just hasn't been. So instead what I've done is I've picked a very important inquiry that closed recently, and the final report was December last year, so it's a very recent report, although it started in 2012, so it's an enormous project. It's one of the biggest, if not the biggest, Royal Commission in Australia. I think it may be the biggest, and it's something which is very significant culturally and legally. So I think it's for all those reasons, it's a very, very good project to look at. Now, we'll be choosing a tiny, tiny selection of that project. The final report went to 20 volumes. It was enormous. It came to me in 3 sort of boxes, and it's an absolutely enormous process. So we're only going to look at one topic. We're going to look at the issues paper and consultation paper number 4, which is preventing sexual abuse of children in out-of-home care. So it's only sort of looking at one part of that topic. And we're only looking at the consultation paper and issues paper at the early stage of the process. You're not going to be required to read the final report. Although if you want to, I'm not going to stop you. And it's certainly a very interesting thing to be able to read through. And you can get access to it online as well. You don't have to deal with the massive print version that I've got. But I've got that so I can actually cross-reference it as I read it. Because I'm going to, look at that in more depth. One thing that is interesting about the report, before we go any further, is that it's a Commonwealth Royal Commission. Ordinarily, this is an issue that's dealt with under state law, under criminal law, and it's going to be an interesting issue that's going to recur as to why it was appropriate to be a federal commission where the actual laws that are affected are state laws. And that has a lot to do with the fact that this is something that needs to be coordinated. But for those of you who are constitutional law buffs, I think that aspect of it you'll find very interesting as well. Alright, so just very briefly, I've mentioned this in another video, but why are we looking at law reform? I occasionally get comments back from students who say, I'm never going to work in law reform, I'm not interested in law reform, why are we doing this? And other sort of negative comments. But law reform is a very useful thing for us to look at. It's for several reasons. It covers the entire spectrum of legal research, and not many other practical examples do that. So we've got legislation, we've got cases, we've got social research, we've got statistics, we've got data. It's one of the few areas of law that brings in all the areas of research. So that's very useful as well. And there aren't very many areas of other areas of law where you have to look at qualitative and quantitative data in the same way that you look as in law reform. And that's a very important skill in terms of employability, because being able to use and interpret data is useful for everyone, no matter what career path you end up on. It's also useful, I think, because it shows how law relates in relation to other disciplines very, very clearly. Law can often end up getting a little sort of introspective and not necessarily see how it fits in with medicine, or how it fits in with public safety, or how it fits in with governmentality and government administration. And law reform is an area where you get to see those things working together practically in ways that you don't necessarily get to look at in other parts of your law program. And the task you're working towards, that short paper, is a very practical sort of task that most people will end up doing at some stage in their careers. Most people or organisations are affected by a law reform issue at some time. And when that happens, your clients or your organisation you work for will have the need to read, understand and respond to current law reform issues. Also, as a professional, as a legal professional, you have an ethical duty to engage with the development of the law. Well, not with everything, not with every law reform issue, but you as a professional, expected to engage with the law as it evolves and as it changes, and to actually be active in that area. So this is something that is practical, and what you'll also find is something that is a slightly different genre, or probably a largely different genre to an academic paper, where you have to be very, very focused and precise, and that's what we're going to be looking for here. We're going to be looking for you to be able to really get to the point. But don't feel apprehensive about any of that, because the weekly modules are there to work you through the process, and you have the feedback process really early on to give you an idea of whether you're heading in the right direction. Alright, so in terms of establishing why law reform is a good thing to look at, why is this particular inquiry a particularly good one? As I've mentioned before, the timing isn't brilliant. Sorry, there are going to be a lot of cuts in this, so you don't have to deal with my cough, which is not very pleasant. Okay, the timing isn't brilliant because it's a closed report. We didn't have the option of something that was current. which is unfortunate because I've done this task for a lot of years now, and it is really useful for students to be able to hand something in as a practical, real-world exercise as an option. It's never been compulsory. But saying that, I would encourage everyone at the end of the term to put your final paper, to reflect on it, put it on your professional portfolio, reflect on it on your blog, distribute it on social media, and do all those kind of professional portfolio things you do to build your portfolio of evidence of your achievements. So even though you're not going to be able to say, well, I handed this into the actual Royal Commission, you'll be able to present that work and show potential employers and others that you have skills in this area. All right. So in terms of why it's a good topic, a good choice generally, it has a lot of meat on its bones. There are so many things going on in this report. It's not an abstract or isolated or erudite topic. It's something that affects a whole lot of people. It's one of the largest, as I said, I think it might be the largest Royal Commission in Australia's history. It ran for 5 years. The data from the Commission's website, they had 40,000 calls that they handled, 25,000 letters and emails, 8,000 private sessions, and 2,500 referrals to the police that came out of this inquiry. Now, we don't know how many of those yet will end up as prosecutions, but that is a massive amount, which is something I have mixed feelings about, because on the one hand, it shows how effective the process is and how important the issue is. On the other hand, it's a really horrific example of how bad the situation is and how endemic some of these problems of institutionalised corruption and criminality are. All right, it's a good topic because it's interdisciplinary, and it has a very interesting contrast between what you could roughly call the therapeutic approaches and the justice approaches. Justice approaches are very much about looking backwards and trying to find solutions to things that have happened. Therapeutic approaches are more focused on trying to actually manage the future and to actually provide help for victims and to provide prevention to stop the crimes happening in the future. And those have very different ideas. Traditionally, the law is very much backward-looking, and it's very punishment-focused, and the idea is you just punish people who do the wrong thing. This is an area where it's clearly not working. We have very significant punishment in this area, and it doesn't seem to be stopping people. And the worst part of it, and this is where the focus on institutional responses is it's not just the offenders who are committing child abuse, it's the organisations that cover up. And that's interesting, and that's quite significant, because many of the previous studies that have been done into child abuse are really about the offender. This one is really about why is it that organisations cover up? Why is it that they undermine victims and don't take victims seriously or protect offenders? And that is a very interesting sort of a topic within that field. This area illustrates the importance of penology, which we'll talk about briefly, which is theories of punishment, and that is, well, why do we punish? Why does the criminal justice system exist? And there are different ideas in terms of deterrence or retribution, or therapeutic approaches, or rehabilitation approaches, and they all have different ideas of why we have a system of punishment. It also asks questions about the limits of law and legal remedies and how far law can actually fix things. If you're a victim of extensive institutionalised abuse, how much can a financial restitution offer you? I'm not saying that the people shouldn't have it, but it's not going to actually fix what's happened to those people. It's also an area in which we find that the assumptions we make around public and private domains is also very important, and how a lot of things that we until recently said, well, that's a private matter, that's not really something for the government to interfere with, is an area where the government is and us as a society are saying, no, we do need interference. We can no longer rely on the goodwill of private institutions to do the right thing by children in their custody, and they can no longer use the protection of the private domain to say, well, this is all just private, this has nothing to do with the state. This is something where we need to make further inquiries. It's an area that has comparative and international aspects, so if you're interested in international law, international legal studies, it's very useful. And it's a wicked problem. It's one of those problems that doesn't have a clear solution. And there's going to be a lot of different combined approaches that we're going to need to solve it. Now, because this subject is such a serious and difficult one, I think it's important from the outset to discuss the well-being aspects around this. Now, it's obviously a topic that has some very horrific consequences. Not much of this is actually in the report itself, so it's not like you'll be viewing upsetting material itself, but the implications and the broader picture and the actual topic itself is one of those that's something that is hard for researchers to contend with. I think it's a very important topic, and we're going to shy away from it, because as legal researchers, we usually have to look at the worst aspects of human behaviour, and the law itself is usually about the most horrible things people do to each other. We don't have laws for distributions of puppies and chocolate. We don't have laws that are about doing nice things for people. We think the best we have are laws that hope to prevent terrible things happening, like contract law is there to prevent people disagreeing and falling out and consequences like that. But most law is about really the worst aspects of human nature, and this is about pretty much the very worst aspects of itself. So I don't feel as though I want to apologise for the choice of the topic, but I am sensitive to the fact that this is a very difficult topic for a lot of people, and if you want to discuss it with me, please take advantage of the consultation times, and we'll have a talk about it. And if this is really, really seriously distressing you, we can arrange other alternatives. But on the other hand, it's a topic that is challenging, and I think that's important. And also figuring out, as a professional, how you maintain well-being in the face of these sort of things, because in all those different legal careers, from legal practice to policy, whatever, you're going to be confronted with horrible issues all the time. And part of learning to be a professional is figuring out what strategies you use yourself to insulate yourself from the stuff that you have to deal with in the workplace. So, yes, the topic is challenging, but it is also one that I'm sensitive to the fact that people may have their own individual reasons for having distressing responses to it, and I'm open to discuss those and to work out solutions to them. Alright, so where to start? I realise this is a very long video. I usually try to keep them sort of 10-15 minutes, but I think it's important to work through this stuff at the start. The first thing I'd like you to do is have a look at the issues paper and the consultation paper. They're on perusal. Usually these two things are the same document, and they're generally called an issues paper, but because of the enormous size of this inquiry, they had to be separated because there was a gap between putting out the initial issues and then figuring out the consultation paper that would analyse those issues. So you can probably read them both together. The issues paper is very short, and it's basically a list of questions. The issues paper is the consultation paper is quite long, and if you don't like reading, law is certainly the wrong thing to study. But for the moment, I don't want you to necessarily have read the whole thing. Skimming through it's a really good idea, but for the moment, focus on the executive summary moving forward, because this paper is going to be the backbone of what we do in this subject, and it's going to provide the framework that we'll be working from. So that's something to start with. Now, in terms of group work, this is not a subject that requires group work. There's no group assignments. However, I do encourage a certain type of group work, and that is where you work in a group where you all have different questions. I don't encourage everyone who works on question 3 to work together, because then you have a very high risk of plagiarism. Not deliberately, but just the fact that you work together on the same topic is going to create risk that you are going to end up tripping up the system somewhere. but have a group of people who are all working on different questions, working together and sharing information. I really encourage it. There's a forum on Moodle that you can sort of go looking for people and try and match people up. Some of you already have groups around your locality that you work with in study groups, and that's fine as well. So I think this is an area where the real professional legal area is always group work. You never do solitary assignments in work, and research is an area which is usually, almost always, group focused. So it's good to get those group skills going, but this is completely voluntary and not required at all. But I do think it's good to be able, when something is this large, to be able to share information and to share opinions. All right, so that's completely up to you, but just letting you know how I stand on that. Now, you will be allocated your question on the basis of the last digit of your student number, which will spread out the questions nice and evenly and give a sort of a random distribution of those questions. I am open to changing your question if you have a strong enough reason to change it. So if you just say, oh, I don't like the question, or I think it looks too hard, that's not a good enough reason. But if you can give me, say, 100 words or so on why you think you would be better answering a different question, and through that demonstrate your understanding of the area, that you've done some reading and you understand it, and you're able to say, look, in my workplace we actually deal with this particular part of the topic, so I think I'm better suited to answer this particular question. Please let me know, and we can arrange a different question if I think there's a strong enough reason. As I said, this is not an invitation to complain that you don't like your question, but if you legitimately have a reason where you can tell me why another question would be more appropriate for you, I'm happy to arrange a different question. And one example of that is if you have a group of people, you've got a study group of say 5 people, and 2 have the same question randomly allocated to them, I'm more than happy to change one of those out for another question. But again, you'll need to give me your reasons and to say, this is the group, we've got these 5 questions, can one of us change this question to another question so that we're not duplicated within the group? Quite happy to do that as well. But otherwise, it's like the real world of work. You deal with what you get allocated. But they're all good questions, and they're all got very interesting consequences and very interesting issues that arise from them. So I think I've really sort of run out of time, well and truly, for a weekly video, but I want to leave you with some questions to ponder and to think about going forward with this. Okay, here we go. First of all, how do we split our attention in law between prevention of future occurrences and resolution of things that have occurred in the past? This is one of those particular difficulties of how is law operating looking backwards or looking forwards in time. And in this case, what is the role of having preemptive strategies to try and stop something happening in the first place? And some of those strategies may be less direct than usual legal strategies. It's about providing structure around reporting and record keeping and agencies. It's not necessarily about punishing individuals and looking backwards. It's about using law to create structures that are protective going forward. So keep that in mind, because there's those two sort of identities that law has. One is the looking back and in a retributive way, or even in a restorative way, and saying these are the things that happened in the past. We have to provide some kind of punishment or restitution. But there's also the aspect of saying, how does law constitute and create new structures that protect people from crime going forward or harm going forward? Okay, second, how does this issue challenge our ideas around public and private? And that is somewhere where we've found that we have really strong reasons why we have an idea of privacy and the private domain as opposed to the public domain. But we also find that there are predators who rely on that distinction to operate, where they can, outrun oversight and responsibility. So what does this mean for our ideas of public and private? And also, what are the dangers about expanding the law and saying, well, we'll delete some of the private domain because of these offenders? What do we lose in that move towards more surveillance and more oversight? the other people suffer because of what the predators have done. Is the idea of increased powers of surveillance and an increased surveillance state the only outcome of this? Or do we have other ways of approaching this that don't mean necessarily that more power to Big Brother, that we provide other solutions? There's a whole set of different issues around federalism and agencies that are very interesting here. Not to go into much depth here, but the way in which our constitution divides responsibility between state and federal government, that's part of the problem. And we have a number of different agencies set up by all these different governments that ideally should be cooperating and communicating with each other, but in reality often end up stepping on each other's toes. How do we deal with those issues? And those very practical issues of how do, the federal police talk to the state police, talk to family services, and so on. And finally, how is law able to enable things that are providing safety and protection for children in the future? Are we able to actually negate and prevent crime from occurring, rather than just trying to deter people and hope that people will be deterred by the punishment that they see others suffering? Are we actually able to use law in that more positive way to create a society that is safer, but without that cost to rights and individual freedoms? Alright, so this has been a very long video, interrupted several times by horrible coughing fits, which I've hopefully edited out. I think this is a good place to end. Look forward to seeing you in the workshop, and I hope you'll find this semester challenging but professionally enjoyable. The subject matter is obviously not enjoyable at all, but I think if you engage and you're very positive about your engagement in this material, you'll actually find you get a lot out of this subject.